as a promise or agreement should be expressed as such and not left to implication. And then it says, and this was in response to your specific question about the evidence, in construing the provisions of a contract, ascertainment of the intention of the parties is paramount, although to carry out that intention, words may be transplanted, supplied or rejected to make its meaning more clear. Where the intention of the parties is clearly and unambiguously set forth in the agreement itself, effect must be given to the intent as indicated by the language used, without regard to extrinsic effects. That's the effect of what's being said here. And there's something quite similar to the sort of officious bystander. Yes, quite. So what's said is, in one of the other judges' decisions, a term may be implied only where it may be assumed that it would have been included if attention had been drawn to it. It's the obviousness if it had been suggested to the parties. So it's not a question of rewriting. It's got to be a question of interpretation. And even if it was a question of saying, well, the commercial context means that this would have been a sensible term in this, and I don't accept that given the fact that the commercial context was, it would need to be completely obvious that this term arose. Yes, of course.
Even if it was not practically feasible for a comprehensive settlement agreement to be achieved by the 31st of March 2016, it's possible that the creditors wanted to have it in their hands the extent of the professional responsibility in order to assist them in the negotiation of the final terms of the settlement agreement. And again, the debtors as well domestic would have to get on and bear that it would be held over as part of the leverage in determining what the final settlement would be, and whether or not simply the conclusion of the settlement, rather than its complete performance, would in any way be in exchange for an agreement that the confession would not be deployed thereafter, except in particular circumstances. There are all sorts of scenarios you lay out.
Yes.
Yeah.
And once one starts down that road, implying some sort of term, there are all sorts of ways in which that term could be drafted. And we see that from the way in which the case is put. The case is put, we were up to date on the day that the application was made. Well, why should that be the term? Why should that be what precludes, rather than, we're in last chance saloon, I'm afraid, you have to comply. If you don't comply and you're in default, well, all bets are off. Why should it be one and not the other? And that is always cited in the English authorities as being one of the reasons for not implying the term, because it has to be obvious that that is the term. And it makes it much more difficult for my own friend that nobody's ever written down the term. What is the term? And that, it seems to me, because we're talking about a fraud defence, that, it seems to me, is fatal for the fraud defence. Because not only does the term have to be sufficiently obvious to be implied into the contract, it has to be obvious that it is implied. Otherwise, you need to point to an individual who knew that this was the term and therefore lied about it. And that's never been articulated. And that's why it seems to me, when the New York lawyers make their submission on paper, they're driven to saying, well, it's absurd to interpret this contract in the way that my clients understood it. Because if it's not absurd, well then it's very difficult to show that my clients did in fact interpret the contract as being permitting them to enter judgment.
All right, well, now, where are we getting now in your
So,
are you going to now move on to your terms argument? Well, if it was subject to
yes.
compliance with the payment plan, in fact, the payment plan wasn't compliant with it.
Yes.
And in particular, this last case involving
Yes.
the last out
Yes.
agreement.
Yes. So what I've dealt with is implied term, but then there's the next stage. The implied term has to be so obvious my client knew and lied about it. And then the third stage, in default of the payment plan. And so I'll take that in two stages. Let's put Skyway to one side for now. Assume my learner friend's right, and those payments can be taken as payments to my client. Even then, yes, they were up to date on the day, on that case, they're up to date on the day the judgment's entered. But they're in default on everything apart from the first two payments. So if we take up my chronology, and my learner friend, in response to questions, your Honour's questions about some of this, said, well, it's a bit unclear about when some of the payments were received. It's not. This chronology is based on the documents and the admissions made in the witness statements by my learner friend's clients. So there's no doubt, and if my learner friend wants to pick up on points, no doubt correct my chronology, he can, but it seems to me that these are taken from witness statements. So if we go to the chronology, what we see are 5 payments of 10 million. So there's no doubt about the dates when the money is due under the term sheet, because that comes from the term sheet, and that's the reference that one has to decide. So if we have 24th of March, you see, the Honour will see first payment, and then second payment, third payment, over the page, fourth and fifth payment. Those are all $10 million, and that takes us to the end of June 2016. So that's the first 50 million, and that's what my learner friend says happened. And then after that, we get all the bit in the middle, which is about the Skyway Fund and the judgment, and then there is 3 further payments due, 6th, 7th and 8th, of $33.3 million, and those have not been made. So that gets us to December, and then at the end of next month, 31st of March, that is when the settlement amount is due, and if that's not paid, then all bets are off, and we're back up to the 617 million. We've already missed the early payment date, which was the early settlement date, which was 30th of September, so they're not getting the discounts that would have been agreed there. So if we go through the payments and the timings of them, the first payment, as we see, is 24th of March, and it's agreed that that was made on the 24th of March. There's no argument about that. The second payment is then due on the 31st, and that is paid on the 31st. The third payment is due on the 30th of April, but it's not paid then, it's paid on the 3rd of May. So if Your Honour would like me, I can take you to the underlying documents and the references to all that. Yes. I'm grateful. So then we go over to page to the 4th payment, and that's the 31st of May. And that's in 2 parts. So this is the one where 5 million was paid into escrow on the 23rd of June, but before that, on the 6th of June, there was a $5 million payment directly there. And so you'll see on the right references to both the documents, and then references to a statement, that's the affirmation of Sushil Bay in the New York proceedings. So these facts come from my learned friend's witness. There's no doubt about the timing, that those payments were late, because they go to the 4th payment, due on 31st of May, and then they come in on the 6th of June, and then the end of June. So the 23rd of June. So it's about 3 weeks late to get to that final payment. Now, in relation to this, there's some suggestion that perhaps there was some variation of the arrangement, the agreement, which gave rise to us accepting late payment and therefore them not being in default of the term sheet. And that comes from the witness statement of Mr. Wright. He doesn't quite say it in terms. What he does, Mr. Wright does, is he exhibits an email from within my client's organisation on which he relies. But that makes clear in terms that there is no variation. email says, well, this does not constitute a variation. So it's very difficult to mount any kind of case that the terms of the term sheet have been varied as a result of that. So I can show that to Your Honour if Your Honour would like.
Is there an intermediate provisional estoppel short of the variation of the view?
That is certainly not a case that's been put anywhere else. In the sense that having received these sums, I'm not entitled to. I've waived my rights. I've somehow. It's never been said. It's never been explained in those terms. And in the circumstances where my client is saying, I don't. This is not a variation of the deal. Pay by this date. It's consistent with the sort of damages.
Your case is that these payments are accepted without prejudice.
Yes. It's never been said that there was some sort of waiver, as far as I'm aware. It's not been put in those terms. But as I say, it's very difficult in circumstances where the correspondence surrounding these payments says this is not a variation.
Yes.
And as to the fifth payment, that is the one which is, it said, satisfied by the Skyway payments. So the fifth is due on the 30th of June. So then the Skyway participation happens subsequently. And obviously, I say the Skyway payments didn't constitute satisfaction of these obligations. But my learned friend takes credit for the two payments that one sees on the 21st of July and on the 18th of August. Now, so does Your Honour see those?
Yes, I do.
Grateful. So Your Honour can see that those are later two ways. So assume that my learned friend's case is entirely right, and we agreed to accept payment pursuant to the participation agreement in this way. Instead, what happens? So under the participation agreement, Your Honour will see the dates when these sums were in fact due under the participation agreement. That's simply set out in the schedule. So they're due, first payment 21st of July, second payment 29th of July. So the first payment comes in on time, pursuant to the terms of the participation agreement, and the second payment is not received until the 18th of August. So it's about almost a month late. And then you'll see that the request for judgment comes pretty soon after that. And again, the receipt of those, the receipt of that subsequent second payment is surrounded by correspondence. And in that correspondence, I can take Your Honour to the emails. All that one sees is chase, we reserve our rights, chase. And there's an express reservation of rights in those emails. So can I take Your Honour to those? I'm great. All right. Yes. Perhaps for your notes, Your Honour, may I give you the page references just to be helpful? 2B, bundle 2B, 463. So if we make the notes next to the 18th of August entry, Your Honour will see that the correspondence leading up to that is found at pages of the same bundle 2B, pages 463, 466, 470. There's quite a lot of it, I'm afraid, but they're short, they're emails. 473, 484 to 486. And again, on top of all of this, for a fraud case, needs to be laid on that my client knew that it wasn't entitled to pursue the judgment. So even if it's arguable that there's some sort of waiver, that needs to be elevated to a case of fraud, and therefore my client knew that there had been a waiver. In relation to the Skyway payments, Your Honour doesn't have a response to the evidence from Mr. Wright about the ways in which this arose. And the reason for that is because of the way that the case has been put. The case is put in New York is specifically...
Put by whom?
by the defendant. So what is said is that the defendant paid $50 million. And so then what was said was that the payments made by Skyway amounted to the defendant paying $50 million. Now, in this court, it's also said in the evidence in this court that the defendant complied with the payment plan. But I say that doesn't work if you look, it can't be right if one looks at the participation agreement, because that makes it clear that there is a debt created by that agreement. And those emails, which I've just referred to, will show that the money that is being paid is being pursued as a payment under that agreement. So what my learned friend is effectively getting around to is saying, well, actually, there is a side agreement, and it emerges through implication of a contract from those emails that my learned friend took you on to. It's a side agreement. Sorry.
I just wanted to tell you what I understand is of the participation agreement and how it works. And you tell me if I've got it wrong, which I may have. What's going on here is that the Skyway part is purchasing from the claimants a right under the credit agreement to be paid in respect of sums due by the defendants. And the purchase price of those rights are the two sums combined. And this is on terms that they will only recoup, exercise their rights to recoup defendants at the end of the process, being the last in line as to who has entitlements under the credit agreement to be paid.
Yes.
Is that right?
Yes.
Now, just speaking provisionally for the moment, prima facie, those are not payments that are going to satisfy the payment plan obligations.
Yes.
But it could be that it's agreed that they will be treated as such.
Yes.
And I think Mr. Jamal's case is, well, that really was the agreement, that they were to be treated as such.
That's his case. He put it in terms of the skeleton argument that there was some sort of financial accommodation. That's the way it was described.
I think orally,
Yes.
that was the sense, I think, what I was hearing.
That's what I was hearing as well. That's not the case as articulated in New York. It's not.
That just reminded me of a sentence or two. What the case articulated in New York is
that the defendant had paid under the payment plan by reference to the.
Without getting into any explanation as to how Skyways and the participation agreement work.
Well, there was reference to Skyway, but there was no explanation. There was some side agreement, and so reading between the lines, one had to. It looks like what is being said in New York is
Simply that the third party is
satisfy the debt.
the third party is also fine.
Yes.
Satisfied.
Yes. Yes.
Yes, I see.
So can I show you that to you? Is it helpful to see that? I'm grateful. I'm grateful.
You can give me the pages that I should look at.
Yes. 2B.
Yeah.
So if one looks at page 512, and then also at page 518, paragraphs 17 to 18. And in this court, it's bundle 1, tab 18, page 80, paragraph 12. the position is put that the defendant complied with the payment plan. So we have a new case, advanced apparently to support a case in fraud against my clients. But it's obvious to my clients, and they knew all along, that what was happening here was that the obligation under the payment plan to make this 10 million payment was being replaced, was being forgiven in some way. So my primary position is what is said. One can explain this in a number of different ways, but what is being said doesn't match the case, and the case is not supported by the evidence. And at the moment we're dealing with fraud, and that is unsatisfactory at best. So, Your Honour, I think I've made the points that I want to make about fraud, the defence, and I'll hear what my learned friend has to say, and maybe something else to be said after that. But at the moment, the question is there a real prospect in this court of establishing fraud on the material that's being supplied? And on that basis, I suggest that this is not just no real prospect of success, but this is not a defence that should have been raised in my submission. That's it for defences, because we know that the existence of the new proceedings is not. So then we're on to stay. And so on the question of stay, my position on stay is, primary position is there shouldn't be a stay in this sort of case. It's not even that. Well, that's it. That's the very point. There's no prospect of repayment, because my learned friend's client accepts that there's in the term sheet that $619 million is outstanding. My learned friend's case is that today his client owes my client $100 million. So there's just no prospect of there needing to be any kind of financial accommodation. Yes.
Then you will receive the sum of money, which you were not entitled to, as it turns out.
Under that instrument? Yes.
When I say you receive the sum of money, meaning that enforced release to pay that
yes.
sum of money.
Yes.
And it would then be for debate whether you could settle against the obligation to repay that sum. The very large debts which are existing in parallel.
Yes. I don't say that this is determinative, but what I do say is that when one considers the two questions, should there be a stay at all? If there is to be a stay, should there be a requirement to pay security as a condition of that stay? When one considers those questions, my submission must be a material consideration in this case. I've made clear my position, and you're obviously relatively receptive to it. The IPCO approach, the solid honour approach that is taken to arbitration awards, there's no obvious reason why that should not be applied to a situation like this one, because the parallels are very similar. And if one looks at solid honour, which is where the test comes from, and it's only created really in 1993, and what's said in that case is, well, there wasn't actually any authority at that stage. It's quite a modern development. And when the Court of Appeal came up with that test, it looked around the world to other authorities to try to get some insight, and said that it couldn't find much help, much assistance from that. So it seems, and then since then, it's obviously been adopted throughout the world, really, as being the the appropriate test to be applied in circumstances like this when one's dealing with an arbitration award. So it does seem to be appropriate to consider that in that sort of test. But so when one looks at that approach, one's looking at the strength.
What's the difference between an alternative, that is one that you mentioned, is to require security.
Yes.
Which would bypass the machinery of enforcement. So long as the security is provided.
I'm not sure I would necessarily agree that it bypasses the machinery of enforcement in the sense that I can't take.
All that we make come to court.
Yes.
And all that obligation to bring the money into court would be achieved without having to go through the usual processes of execution.
Execution, certainly. Yes. Yes, that's quite right.
Perhaps I misused, but I should say execution.
Yes.
Through the processes of execution.
Yes. And the reason why that condition is often imposed is because a stay prevents me from pursuing that path, and let's face it, that is likely, even after a judgment of this court, to be a long process and a difficult process, and maybe fruitful, may not be. So the choice then for a defendant faced with an obligation to provide security as the price for a stay is to say, well, just on a purely commercial basis, how far is the claimant going to get? Because if during the period of the stay the claimant would otherwise have got all the way to execution during the period of the stay, well, then I'll pay my money into court. And that's fair because the stay has prevented the claimant from getting there. But if during the period of the stay the claimant wouldn't have got to that period, well then it's open to the defendant, wouldn't have got to execution, and it's open to the defendant not to pay the security. But then it's only right that the claimant should be entitled to follow down that road as far as it can during that period. And so that's why security is the price for a stay. And it effectively puts the choice into the hands of the defendant. And it's a difficult choice to make on a purely commercial basis, but that's not unfair in the context that one is in, with an apparently enforceable judgment subject to these sorts of complaints that are going on in New York. And that's why it's right, it seems to me, that in this case, if you're honest-minded to say, let's just, no matter how improbable it seems, let's see what happens in New York, that my client ought to be able to make progress in the interim. Because it's been, as I said, 6-7 months since we got this judgment, which itself followed a long process of drip, drip, drip payments, all of which, many of which had to be extracted, which in itself originates from a notice of acceleration issued a year ago. So we're a year down the line of pay us, now it's the last charge.
The execution on the DIFC
Yes.
judgments.
Yes.
And recognise the judgments of recognition in force.
Yes. That's right. It's said that there are no assets in the DIFC. My learned friend maintains that position. And that is a position which has consistently been advanced in pretty much all of the cases where parties have resisted enforcement of arbitration rules. And the only time that has genuinely been tested was in one of the arbitration cases where I appeared in front of Samson Coleman and actually cross-examined the person who was making that assertion. And Samson Coleman's judgment was actually, on the facts,
There was assets.
Well, no, not that there were assets, but that there arguably had been assets, and he could take nothing from the evidence of that witness either way to say whether or not there were still assets. And so, and that was following, because we had a trial, which is an unusual situation when you're enforcing an arbitration award, but I think what that illustrates is that when we get this far down the line with what I would describe as a delinquent debtor, it's a debtor who clearly owes money, but it's just not paying. Why should we be expected simply to take their word for it, that they don't have assets in the DIFC? They say that their only connection with the DIFC is they took out a loan through a DIFC branch of a bank. Well, so they have some connection with the DIFC, and it may be that the execution mechanisms within the DIFC can nevertheless be used to attack assets.
I assume one of the powers exercised by the courts is to compel attendance and cross-examination on
Quite.
production of documents and everything else.
So that is absolutely right, and there has been an argument in the DIFC court about the scope of those powers. Can, in effect, the DIFC reach out into Dubai and require officers living or who are in Dubai to provide that sort of... I had an argument on that, and I lost. You can, the DIFC court can do that. So the DIFC does do that. So it summons parties, officers. Your Honour sat on one of the cases where the rules about that were established. I forget the name, but Your Honour found a way around what was in effect quite a strict rule, which suggested that the company needed to be present in the jurisdiction. There's a rule in England that sort of rule should be limited to the geographic territory of the country. And I'm afraid I forget the name, but Your Honour found a way around it by ordering the company, effectively making the company. That was in England. Yes. Yes. Oh, I see. Yes. No, not here. No. It never reached. Yes. So there was a similar sort of argument, and my position in one of the cases was the powers of the DIFC should be similarly territorially limited to the DIFC, and that was not a winner. So yes, that is one of the powers. The other things that have happened, for example, in the Boston case, is that Justice John Chadwick, when he was the Deputy Chief Justice, made a freezing order. And in fact, he made a worldwide freezing order in support of the enforcement of post-judgment enforcement of an English judgment, extending into Dubai. Now, I'm not suggesting that is something that I'm applying for, but the point is that the mere fact that there are no assets doesn't necessarily mean that the execution mechanisms of this court can't be of assistance to my client. And then similarly, what the DNB Bank undoubtedly does establish is quite. So.
Now, what about the fact that you're seeking enforcement in different jurisdictions?
Yes.
And each of those courts might think it were appropriate for security.
Yes.
You might have orders for security that overtop the amount that in fact is due.
Right. So that will, at the moment, there is no order for security, and that will depend on the terms of the orders that are made. I accept that it must be right, but the defendant shouldn't have to put down $171 million multiple times. And so but I think that can be addressed in the terms of any order that this court would make. And if I would not be arguing for a conclusion that there should be multiple security, but I can't see how that can be a principle response.
You give an undertaking that if security is ordered in this case, that you won't seek security elsewhere, which would lead to an aggregate sum in excess of the overall sums that are due.
I will take instructions on any question like that, but I would have thought that security simply being ordered is unlikely to be sufficient. I think that the harm is if security needs to be posted or has been posted. If security is posted in this jurisdiction, it's not been ordered anywhere else.
Yes, I see. Yes,
Yes.
Yes.
Because what I wouldn't want to...
Yes. What I'd like to get instructions on is along those lines.
Yes.
If security is,
Yes.
then you will not require the provision of security elsewhere in circumstances where the aggregate of the placings exceeds the
Yes.
overall sum due.
Yes. And I will need to take instructions, but that makes sense. And it's certainly not, as I understand it, my client's position. We actually want money to be put down in every single jurisdiction. One knows the commercial realities of these sorts of things, though, and there we are. On the questions today, I want to bring. I made submissions about timing. Your Honour was asking about the timing of the challenge in New York, and one of the tests under the Sorbonne approach is this a bona fide challenge? And I would suggest that the way in which, the timing in which these issues have emerged suggests otherwise. It's not just about the merits, it's about the fact that this is a defensive matter, didn't take advantage of the obvious route, which was the 30-day appeal in New York. Instead, they waited for enforcement proceedings to be up and running, and then took the approach in New York. And the response, as I understand it, in New York to that is simply, well, we're entitled to do it, so you can't criticise us. It does rather colour this question, whether or not it is bona fides. And the point on that really is that the result of waiting means that we lost 3 months at the outset, because the judgment was in August, and then it wasn't until November that the motion was made in New York. And so if my learned friend's position is we'll wait and see what happens in New York, the court ought to take into account the fact that we would be further down the line in New York if they moved further. Just one more point, which is one thing I want to show you, which is about this question. One of the factors is delay and prejudice which might arise. There is some evidence about the things that have been done to make it more difficult, or which will make it more difficult, to put it neutrally, for my clients to enforce. And in particular, there's just one thing I would like to tell you about, something that happened in BVI. One of the primary targets for enforcement in the BVI was a large sum of money, a receivable, which was due to the defendant from one of its subsidiaries. We wanted, yes, quite, so a third-party debt order and such, and that was really, it was about $294 million. It's an intercompany debt. And in proceedings in the British Virgin Islands, the defendant filed evidence in response. In one paragraph of that evidence, what it says is that that loan from this company called EGAL to the defendant has been converted into shares in EGAL. So now instead of having money, the defendant has shares in this associated company, and those shares have been pledged already to secured lenders. So by that mechanism, this $294 million debt has been converted. Well, the question of whether we apply for freezing order is one thing. I ought to be fair to the defendant. The defendant's response to this is there's nothing untoward about what it's doing. This is not an illegitimate dissipation of assets. This is just in an ordinary course of business. And so the point there, though, is that for a Moravia, I would have to show that it was outside the ordinary course of business. I would have to show that it was an illegitimate dissipation of assets. But my point today is that I don't need to go that far. All I need to show, Your Honour, or I don't need to show Your Honour, but one of the factors that is relevant for Your Honour is that as time passes, these sorts of things will happen if they are in the ordinary course of the defendant's business. And assets like this will be put out of our reach. Whether it's right or wrong, we can all take a view on that, but that is what will happen. The only response... They may be. If we get into insolvency proceedings, they may well be. But what has happened then is that the target, relatively straightforward, some of the money now can go off to this associated company, has been turned into something much more difficult. And so we're having this, there are developments, there will be developments, no doubt, along the way which are similar to that, because the only response is this is how we do business. We move these sums, we change them. Correct. The difficulty here is that share capital was already pledged to somebody else. And so we are now in line after them. And this, as I say, will continue to happen. Your Honour, unless there's anything I've missed, I'm grateful.
Your Honour, I apologise for not dealing with the immediate judgment application, but as I understood it, you'd suggested that I knew that after Mr. Montague Smith made his application for immediate judgment.
Yeah, that's fine.
So, Your Honour, if I could address first the defence based on natural justice. Your Honour, the defendants rely on a case at tab 8 of the bundle, of the defendant's bundle. If I could take you to that case.
This is your bundle, bundle 1.
Your Honour, yes. And that is the case of Jacobson and Freshon.
Yeah.
And Your Honour can see from the brief head note that this concerned an action for a breach of contract. And in this case, what happened was that the expert appointed by a foreign court didn't properly carry out its duties, or that was the allegation.
Yes.
And so it was said that was contrary to the rules of natural justice. If I can take you to page 392. Lord Justice Atkin, in considering what is meant by the rules of natural justice, at the bottom of the page in the first column,
Yes.
says, the master of the role seems to prefer, and I can quite understand, the use of the expression contrary to the principles of natural justice. That is a reference to the expression substantive justice. Substantial justice. The principle, it is not always easy to define or to invite everybody to agree with that, whereas with our own principles of justice we are familiar. Those principles seem to me to involve this. First of all, that the court, being a court of competent jurisdiction, has given notice to the litigant that they are about to proceed to determine the rights between him and the other litigant. The other is that having been given that notice, it does afford him an opportunity of substantially presenting his case before the court. Now, we say that in this particular case, the procedure in New York doesn't permit for either of those occurrences. And as a result, that procedure itself conflicts with the English rules of natural justice. And my learned friend cites a case, I think it's Balance, which is at the end of his authorities bundle. But we say that's not really on point, because in that case, the facts were that the defendant had bought into a company in France, and as a result of buying into that company, was deemed to have a domicile in France, and was served at that domicile. So whereas he didn't actually receive notice because he wasn't in fact domiciled in France, the court said that the procedure that you're deemed to have bought into by your agreement, i.e. your purchase of these shares in this French company, is such that you are deemed to have service.
Yeah.
That isn't really the same as this case, where there is no requirement for notice whatsoever, and there is no opportunity given to us to appear. Now, the basis of the challenge in New York is that the rule 317, on the basis of which this challenge is made in New York, uses the word summons. The learned friend says it's applicable to default judgments. Whether that's right or wrong is not really an issue. But the word used is if you're served with a summons. If you're given notice of a summons, or that you don't have notice of it. And the obvious point that's taken is that a confession of judgment doesn't engage any sort of summonsing. It is an automatic filing. But we would say that that makes it even more egregious in terms of the rules of natural justice. And the argument that's been made in New York is that, notwithstanding that it's a confession of judgment, it is still subject to due process rules, where we should be given notice of it, pursuant to this particular rule.
Yeah.
So, in my submission, that is a credible defence that is open to the defendant, and one that this court cannot rule on without necessarily the New York court having determined its own position on whether or not notice should have been given to my clients of the entry of this judgment. And whether you look at it in terms of a stay or a defence to the immediate judgment application, we would say it's a defence to the immediate judgment application because it is plainly in breach of the English rules of natural justice. So that deals with the natural justice point, Your Honour.
Yeah.
Your Honour, moving on to the fraud point, the use of the word fraud is perhaps slightly unfortunate, and it's lifted from the New York proceedings, which speak in terms of fraud, misrepresentation, or misconduct. Now, in our submission, the Derry and Peak type of dishonest, deliberate fraud is not the kind of conduct we are here dealing with.
Well, look, this defence that is put forward is a defence in this court with the enforcement application. And the fraud which has to be established in order to vacate, let me rephrase that, the fraud that has to be established in order to disentitle the judge and creditor from an order of enforcement is the English notion of fraud. So that you have to show, for instance, perjured evidence or bribery or something of that sort.
Well, Your Honour, we would say that the cases don't really bear that out. If I could take you to tab 10, and that is the case of CL and Hayward. In that case, a judgment was entered in India for 20,000 rupees, and when it came to enforcement, it was suggested that it would be fraudulently entered because in fact there'd only been a loan of 10,800 rupees. If you go to page 444, at the bottom of the page it starts, the main basis of the defendant's allegation of fraud was that the plaintiff had deceived the court by pretending that he had lent the piece 20,000, whereas in fact he had only lent the piece 10,800, thereby concealing from the court the possibility that the defendant might have a defence under the Indian Usurious Loans Act, which corresponds to the Moneylenders Act in this country. So that was the basis for the allegation of fraud. And if I can then take you to page 448. About 6 lines down from the top. It said, in cases under Section 4 of the Act of 1933, the question is not one of fraud on the plaintiff, but of fraud on the court. And it seems to us to be clearly established by authority binding on us that if the defendant shows a prima facie case that the court was deceived, he's entitled to have that issue tried, even though in trying it, the court may have to go to defences which could have been raised in the first trial. So, and then there are references to Abuloff and Oppenheimer and Vidala and Laws. Now, we say all we need to do is to show a prima facie case that the court was deceived, to establish conduct sufficient to vitiate a foreign judgment as being enforceable under this particular heading. So we don't need to show that that deception was necessarily deliberate. Well, not wholly innocent, but not necessarily intending to actually, not dishonest either. That there's a line between, that there is a gulf between innocence and dishonesty. And we would say somewhere in between the two.
Well, the guarantee is the statement is made knowing that it is untrue.
Your Honour, yes.
And intending it to be the lie. And that is dishonest. Anyway, I've got your point. You said that something, if the court has been misled, albeit without any dishonest intention, then that's not, that's your position.
Your Honour, yes. We rely also on a further authority, Jack Holdings and Patel,
Yes.
which is at tab 13 of my bundle.
Yes.
If I could just invite you on to read the head note from page 335H to 336C, and that'll give you a flavour of what the case was about. we go to page 345 at H, Lord Justice Thornton then sets out what the defendant's case is. And it's not that there was fraud in the cause of action itself. He doesn't resist enforcement on the ground that he had misappropriated none of the plaintiff's money, and that the plaintiffs were fraudulent in asserting that he had misappropriated money. So, in a sense, his allegation here is of collateral fraud. He asserts that the plaintiff's conduct was fraudulent in, firstly, assaulting him with violence and threats so that he was afraid to go to California, secondly, obtaining $100,000 from him by those means so that he was unable to afford continuing legal representation in California, and three, failing to invite the Californian court to take that $100,000 into account. If we can then go on to the section at H on that page. He says, it is, I think, clear that the plaintiff's Californian lawyers were asserting to the court implicitly and even to some extent expressly that the defendant's account of violence, threats and fear was untrue. If in fact it was true, that assertion, together with the actual incidents relied on, is capable of amounting to fraud in this context. See the speech of Viscount Delhorn in Crown against Humphreys, where he quotes a passage from Spencer, Barrow and Turner, res judicata, with approval. The fraud necessary to destroy a prima facie case of estoppel by res judicata includes every variety of mala fides and malapraxis, whereby one of the parties misleads and deceives the judicial tribunal. Although that was said in the context of estoppel by res judicata, I cannot see that it is any less applicable in the context of enforcement of a foreign judgment, nor apparently did Viscount Dilhorn, since in that passage he also cited Abeloff and Oppenheimer and Vidala and Laws. So, Your Honour, we rely on that again as saying that all we need to do is show that the court was misled. And in our submission, if we need to go beyond that, my learned friend says we need to show that his clients not only appreciated the implied term, as he puts it in the term sheet. We don't actually make the argument on the basis of implied term. We simply say it would be commercially absurd reading of the term sheet to permit them to enter a confession of judgment when there is a payment plan. Your Honour pointed out that it was commercially unreasonable as well. So, in those circumstances, we say it was a conscious decision by the claimant's New York attorney to not make any mention of the payment plan or of the term sheet, which made this obvious to the court in his affirmation in support of the entry of judgment. To the extent that that must have been a conscious decision, because he must have been aware of the payment plan. He mentions the $40 million paid, but he doesn't say it was made pursuant to the payment plan.
But in the clause which contains the date of 31st of March 2016 is to be construed in the manner that your opponent seeks to construe it, then all that the court needs to be informed of is that this date has arrived in the past, and therefore there can be an application for judgment pursuant to the confession. And just looking at the clause on the face of it, that provides for an entitlement after that date to seek judgment. One then asks, well, how does that all fit in as a matter of common sense and commercial? And although at first blush it may appear to
Your Honour, I fully take the force of that. The difficulty that I have with it is that what Your Honour describes as a short breathing space is barely enough time to pause for a gasp of breath. It's between the 18th and the 31st of March when the term sheet is entered into and these concessions of judgment can be entered. Now, the relationship between that and any definitive settlement documentation is unclear, as the definitive settlement documentation was due to be agreed by the 24th of March. So that has no bearing on the date of the 31st of March. The warding off of winding up proceedings is likewise not really an issue because the clause provides that not only will the confession of judgment be amenable to entry on the 31st of March, but so will winding up proceedings be amenable to be restored. So why on earth would the defendants on the 18th of March enter into a commitment whereby they are getting nothing in effect to advance their position except a period of...
They're in mercy. And what the creditors are saying is we will judge you, we have a complete ability to use this confession, and we will judge how you proceed with payment accordingly, but without any restriction on our freedom to deploy the confession. Now that's a very hard position to take, but it's not bizarre or obviously fantastical. It's a very hard-nosed position. Anyway, you've made the point that you don't have to show any people, and you say that your case is not founded on an implied term, it's founded on an interpretation argument, which is that this is so absurd that it can't mean what the defendant said. Now, I understand both those positions.
Your Honour, I'm grateful for that indication. Your Honour, there is one further point in terms of resisting the summary immediate judgment application, and that is that we say that in concluding that the matter is appropriate for immediate judgment, you would necessarily have to be deciding matters of foreign law, because the way the argument is structured, or the way the argument is approached, is to say that we have no conceivable defence. Now, if we do have a defence in New York, we must have a defence in this court, because if the defence in New York is successful, there is no judgment to be enforced at all.
But doesn't that go to stay rather than to whether or not an enforcement order ought to be made in the first place? If the law is, well, let me put it this way, if the conclusion of the court that the judgment issued complies with the rule cited not, so that the pendency of the two notices of motion do not render this judgment anything other than final and conclusive for the purposes of the rule.
Your Honour, yes it is, save for the issue of whether or not the judgment is raised judicata in New York, which is a matter of New York law, as my learned friend has been submitting, and which we don't necessarily accept. We say that the status of the judgment as raised judicata in New York has to be looked at from the point of view of the DIFC court's understanding of what raised judicata is. But nevertheless, to the extent that it's my learned friend's submission that if it is raised judicata in New York, it must be enforceable there, and therefore it is enforceable in this court, that is not an accepted proposition of New York law, and that needs to be determined before this court can decide that the judgment is actually final and conclusive. So there is that issue of New York law, which effectively precludes this court's determination of the finality and conclusiveness of this judgment. Your Honour, if I could deal with the stay point in general.
Now, this is an important